Cell doors just closed on a defense team inside a federal courthouse. Not metaphorically, literally. U.S. Marshals physically removed multiple defense attorneys from Judge Sarah Caldwell's courtroom and walked them directly into holding cells after what witnesses are calling the most explosive judicial confrontation in decades. The lawyers weren't defendants. They were the defense, and now they're behind bars. Judge Caldwell didn't flinch, didn't warn, didn't negotiate. She issued the order, marshals moved, and within minutes, attorneys who walked into that courtroom representing their client walked out in custody. When a federal judge has defense counsel detained mid-trial, you know something catastrophic just happened. Here's what went down. So what triggered this unprecedented judicial action? A direct, sustained, and deliberate defiance of court orders that Judge Caldwell had issued repeatedly over the preceding weeks. Orders the defense team chose to ignore, mock, and openly violate in front of the jury. This wasn't a heated objection that went too far. This wasn't a lawyer losing their temper in the moment. This was systematic obstruction of federal court proceedings that culminated in what prosecutors are calling the most egregious display of contempt they've ever witnessed in a federal courtroom. And I have the court filings, the witness accounts, and the judicial order right here. The order itself runs 18 pages. Judge Caldwell details with surgical precision every violation, every warning, every chance she gave this defense team to correct course. They didn't just refuse, they escalated. According to sources inside the courtroom, the lead defense attorney looked directly at Judge Caldwell after her final warning and said something that made the entire gallery audibly gasp. What happened next will redefine how attorneys approach federal courtrooms for decades. Let me show you exactly what the documents reveal and what they're desperately trying to spin. Here's what the court filings and witness accounts actually show. The 18-page contempt order signed by Judge Caldwell details 17 separate instances of what she termed willful and calculated defiance of lawful court orders. This is it. This is what everyone's talking about. The violations began 3 weeks before the removal, when Judge Caldwell issued a pretrial order prohibiting either side from referencing certain prejudicial material that had been excluded during motions. The defense referenced that material anyway, 3 times. In their opening statement alone, Judge Caldwell issued an immediate warning. She directed the defense to approach the bench. According to the court transcript, she stated explicitly, "Counsel, you are on notice. One more reference to excluded material, and I will find you in contempt. Do you understand?" Lead defense attorney Marcus Rennert reportedly responded, "Understood, Your Honor." The next day, he referenced the excluded material again, this time in front of the jury during cross-examination of the prosecution's lead witness. But here's the kicker. When Judge Caldwell called a sidebar to address the violation, Rennert allegedly told her, and I'm quoting from the court filing here, "Your Honor, with respect, I believe your exclusion order was incorrectly decided, and I intend to appeal. Until then, I'm going to present my client's defense as I see fit." A federal prosecutor present in the courtroom told reporters that Judge Caldwell's face went completely still when Rennert said that. She didn't respond immediately. She returned to the bench. She instructed the jury to disregard the reference. And then she issued her first formal contempt warning on the record. That should have been the wake-up call. Instead, the defense doubled down. Over the next 11 court days, the defense team, which included Rennert and 2 associate attorneys, committed what Judge Caldwell cataloged as an escalating pattern of deliberate violations. They spoke over her rulings. They addressed the jury after being instructed to stop. They submitted motions that had already been denied 3 times, forcing the court to repeatedly re-adjudicate settled issues. On day 14 of the trial, Rennert refused to stop speaking when Judge Caldwell sustained a prosecution objection. He kept talking for nearly 40 seconds while she repeatedly instructed him to stop. The court transcript shows she had to have the court reporter read back, "The record will reflect counsel continued speaking over the court's ruling" 6 separate times that day alone. And then came the moment that ended everything. During what should have been routine testimony, the defense introduced an exhibit that had been explicitly excluded, not just by pretrial order, but by a ruling Judge Caldwell had issued that very morning. When the prosecutor objected, Rennert turned to the jury and said, again, I'm quoting from the filing, "Ladies and gentlemen, the court doesn't want you to see this, but I believe you deserve the truth." Judge Caldwell called an immediate recess. When proceedings resumed 45 minutes later, there were 4 U.S. Marshals positioned near the defense table. Judge Caldwell read an 8-minute statement from the bench. She detailed every violation. She noted every warning. She cited every opportunity she had given the defense to comply. And then she said the words that are now echoing through every federal courthouse in America. "Counsel, you have left this court no choice. You are held in criminal contempt. Marshals, remove the defense." The defense team was handcuffed at their own table, in front of a jury, in front of their client, in front of the gallery. Court sources confirm they were processed through the courthouse holding facility and remained in custody for over 6 hours before a magistrate judge set bail conditions. Hit that subscribe button right now because this story is evolving by the hour and you won't want to miss any of the developments I'm covering. The legal implications here are massive, and I'm breaking them all down in upcoming videos. Now you've seen what happened, but here's how we got here. And it makes the whole thing even more significant. This trial wasn't random. The defendant in this case is Raymond Voss, a former senior aide to a prominent political figure facing multiple federal charges, including wire fraud, obstruction of justice, and conspiracy. The case had been politically charged from the beginning. Tensions had been building for months, fueled by defense claims of prosecutorial overreach, media coverage that favored the prosecution, and a defense strategy that seemed designed to turn the courtroom into a political theater. Everything escalated when Judge Caldwell, a George W. Bush appointee with a reputation for strict courtroom management, was assigned to the case. The defense immediately filed motions to recuse her, claiming bias. Those motions were denied. They filed appeals. Denied. They filed emergency stays. Denied. According to legal analysts who reviewed the pretrial filings, the defense strategy appeared to shift at that point. Instead of litigating the case on the merits, they began what one former federal prosecutor called a systematic campaign to create appealable error. The theory, reportedly, was simple. If they couldn't win the trial, they would make it impossible for any conviction to survive appeal by forcing the judge into actions that could be characterized as prejudicial. Judge Caldwell saw it coming. In a pretrial conference, she stated on the record, and this is from the transcript, "I want to be absolutely clear with all parties. I will not be baited. I will not be provoked, and I will not allow this courtroom to become a circus. Counsel who violate my orders will face consequences. I hope that's understood." The defense responded by violating her first order within 72 hours. What followed was a 3-week escalation that court observers described as unlike anything they'd ever witnessed. Defense attorneys interrupted the judge. They rolled their eyes visibly when she ruled against them. They made statements to the media on courthouse steps that directly contradicted her gag order. By the second week, Judge Caldwell had issued formal warnings on the record 7 times. By the end of the third week, she had found the lead attorney in civil contempt twice and fined him a total of $45,000. He paid the fines and kept violating. That's when Judge Caldwell realized civil contempt wasn't working. And that's when she made the decision that will define her legacy. Smash that like button if you're following this. The algorithm needs to know this content matters, and your engagement directly helps more people see the truth about what's happening in our federal courts. Drop a like right now. It genuinely helps. The bombshell moment came at 10:47 a.m. Eastern. Court sources described the scene in vivid detail. The courtroom was packed. The jury was seated. The prosecution's witness was on the stand. And then Rennert introduced Exhibit 47D, the exhibit that had been excluded that very morning. The prosecutor shot to her feet. "Objection, Your Honor. This exhibit was excluded 3 hours ago." Rennert didn't stop. He held the document up toward the jury box and said, "Ladies and gentlemen, the court doesn't want you to see this, but I believe you deserve the truth." Witnesses say Judge Caldwell's gavel came down so hard the sound echoed through the gallery. "Recess! Now! Clear my courtroom!" The jury was removed first, then the gallery, then the press. For 45 minutes, the courtroom sat empty, except for the judge, her clerks, and the attorneys. When the doors reopened, 4 U.S. Marshals walked in and took positions behind the defense table. Marcus Renner reportedly looked at them and smiled. He wasn't smiling 5 minutes later. Judge Caldwell's statement was measured, methodical, and devastating. She read each violation into the record. She noted each warning. She cited the legal standard for criminal contempt with precision. And then she gave the order. Marshals, remove the defense. The sound of handcuffs clicking shut in that silent courtroom is something witnesses say they'll never forget. That's when it became clear this isn't just another contempt case. This is a federal judge drawing a line. Stay with me because the historical context here is stunning, and the expert analysis coming up changes how you'll see this entire situation. But first, drop a comment. Have you ever seen anything like this? I read every single one. This isn't the first time a defense attorney has been held in contempt, but the way it happened here, that's nearly without precedent. Think back to the Chicago 7 trial in 1969. Defense attorney William Kunstler was held in contempt over 20 times during those proceedings. Judge Julius Hoffman's handling of the case became infamous. Citations were issued for everything from arguing too forcefully to simply expressing displeasure with rulings. But here's the key difference. Those contempt citations were largely viewed as judicial overreach. Kunstler became a folk hero. Judge Hoffman became a cautionary tale. Judge Caldwell clearly studied that history. Her approach was the opposite of Hoffman's. She gave warnings. She documented everything. She created an 18-page record that details each violation, each opportunity to comply, each escalation. Then there's the case of attorney Joseph Fine in 1988, who was jailed for refusing to reveal client information. He served 18 months. But that was about attorney-client privilege, a principled stand, however controversial. What Renner did was different. He wasn't protecting his client's secrets. He wasn't taking a stand on legal principle. He was systematically violating court orders in what appears to be a calculated strategy to create chaos. The closest parallel might be the 2004 contempt citation against attorney Lynn Stewart, who was convicted of helping her client, a convicted terrorist, communicate with his followers. She was eventually sentenced to 10 years in prison. But even that case involved actions outside the courtroom. What makes the Caldwell case unprecedented is that the contempt occurred in real time, in front of a jury, in open defiance of direct judicial orders. Legal historians are already calling it a defining moment. The pattern is clear. When attorneys push too far, consequences eventually follow. The question has always been, how far is too far? Judge Caldwell just answered that question in a way no federal judge has in decades. Legal experts are calling this unprecedented, not because contempt is rare, but because the manner and timing of enforcement is almost unheard of. Jonathan Turley, the constitutional law professor at George Washington University, told reporters that Judge Caldwell's actions represent a textbook response to what appears to be deliberate judicial sabotage. He noted specifically that the 18-page order isn't just legally sound, it's strategically brilliant. She created an unassailable record. Any appeal will have to contend with 17 documented violations and repeated opportunities to comply. This isn't a judge who lost her temper. This is a judge who laid a trap and watched the defense walk into it. Meanwhile, Ellie Honig, the former federal prosecutor and CNN legal analyst, emphasized the practical implications. What people need to understand is that criminal contempt isn't a slap on the wrist. These attorneys are facing potential prison time, real prison, not a fine, not a bar referral, actual incarceration. And given the record Judge Caldwell created, I don't see how they avoid it. He added that the courtroom removal was particularly significant. Having Marshals handcuff defense attorneys in front of a jury sends a message that will echo through every federal courthouse in America. You can push, but there's a line, and this judge found it. A former clerk for the D.C. Circuit Court of Appeals, speaking on background, offered additional context. Judge Caldwell is known for being methodical. She doesn't make impulsive decisions. The fact that she went to criminal contempt and ordered removal in open court tells me she believed this was the only way to preserve the integrity of the trial. And honestly, looking at that record, I think she was right. Even some conservative legal commentators who might be expected to sympathize with the defense have acknowledged the severity of the violations. Andrew McCarthy, the former federal prosecutor and National Review contributor, wrote that whatever you think about the underlying case, there's no defending what these attorneys did. A court order is a court order. You comply or you face consequences. That's not judicial tyranny. That's the rule of law. Harvard Law professor Lawrence Tribe put it even more bluntly. This is what judicial courage looks like. Judge Caldwell knew she'd face criticism. She knew this would become a political flashpoint, and she did it anyway because the integrity of federal proceedings demanded it. The legal consensus is remarkably unified. Whatever happens next, Judge Caldwell followed the book. Do me a favor and hit that like button if this analysis is valuable to you. It genuinely helps the algorithm understand that people want in-depth legal breakdowns, not just surface-level coverage. Your like directly helps more people find this. So what does this actually mean going forward? First, the immediate legal consequences for the attorneys themselves. Marcus Rennert and his 2 associates are facing criminal contempt charges that carry a maximum penalty of 6 months imprisonment per violation. With 17 documented violations, the theoretical maximum exposure is significant. The legal experts suggest actual sentences would likely be far lower. More damaging may be the professional consequences. The attorneys face almost certain referral to their state bar associations for disciplinary review. Criminal contempt findings typically trigger automatic investigations. Depending on the outcome, they could face suspension or even disbarment. For Rennert specifically, this could end a 30-year legal career. Second, the impact on the underlying trial. Judge Caldwell declared a mistrial immediately after the removal. The defendant, Raymond Voss, will now face a new trial with new defense counsel. Prosecutors have indicated they intend to retry the case. But here's the complication. Voss's new attorneys will undoubtedly argue that the contempt circus prejudiced their client. They'll seek dismissal. They'll claim he can't get a fair trial now. They'll point to the media coverage and argue the jury pool is tainted. Judge Caldwell anticipated this. Her order specifically notes that she found no evidence that the defendant directed, encouraged, or was aware of counsel's strategy of deliberate violation. She's protecting the prosecution's ability to retry. But appeals courts can be unpredictable. The defense will file. They'll argue everything. And some of those arguments might find sympathetic ears. Third, the long-term implications for federal practice. Defense attorneys across the country are watching this case with intense interest. Some see it as a cautionary tale. Others see it as a template. The fear in some quarters is that Judge Caldwell's approach could embolden other judges to crack down on aggressive defense tactics. Tactics that, while sometimes annoying to courts, are often legitimate advocacy. The counter-argument is that Caldwell's careful documentation proves the opposite. She didn't punish aggressive advocacy. She punished deliberate defiance. The distinction matters. The implications for rule of law are profound. If defense attorneys believe they can violate court orders with impunity, federal proceedings become unworkable. But if judges overreact to legitimate advocacy, defendants' rights suffer. Judge Caldwell walked that line. Whether she walked it correctly will be debated for years. Legal ethicist Stephen Gillers of NYU Law noted that this case will be taught in professional responsibility courses for decades. It's a masterclass in how far is too far and what happens when you cross the line. The American Bar Association has already signaled it will issue formal guidance based on the case. Whatever that guidance says, one thing is certain. Every federal defense attorney in America is rereading their ethics rules right now. And then the defense made it even worse. Within hours of being released on bail, Marcus Rennert held a press conference on the courthouse steps. Instead of expressing any contrition or acknowledgement of the court's concerns, he went on the attack. What happened today was judicial tyranny, Rennert told reporters. Judge Caldwell has proven what we've alleged from the beginning. She's biased, she's vindictive, and she's determined to secure a conviction regardless of my client's rights. He called the contempt citations manufactured and the removal political theater designed to intimidate defense attorneys everywhere. When asked about the specific violations documented in the 18-page order, Rennert dismissed them. These so-called violations are nothing more than zealous advocacy. I make no apologies for fighting for my client. If that's a crime now in America, then we've lost something fundamental. Here's the problem with that response. It directly contradicts the documented record. The violations weren't judgment calls. They weren't aggressive advocacy in gray areas. They were direct, documented defiance of explicit orders. When you introduce an exhibit that was excluded 3 hours earlier and tell the jury the court doesn't want you to see this, that's not advocacy. That's sabotage. Former federal judge Nancy Gertner, now at Harvard Law School, pointed out the flaw in Rennert's strategy. The worst thing you can do after a contempt finding is attack the judge. Judges talk to each other. Bar associations take note, and appellate courts read press conferences. Every word he said today will be in the prosecution's sentencing memo. She added, if he had come out, acknowledged that things got heated, expressed respect for the court while preserving his appellate arguments, that's defensible. This performance? This hurts him. Other members of the defense bar have been notably silent. Legal ethics experts note that public support for Rennert could be seen as endorsing his tactics, something most attorneys aren't willing to do. When your defense is attacking the judge rather than addressing the documented violations, you've already lost the argument. And Rennert's press conference may have just made his criminal contempt sentencing significantly worse. But beyond the immediate legal fallout, this is really about something much bigger. This is about whether courtrooms can function. Every trial in America depends on a basic compact. Attorneys advocate zealously, judges rule fairly, and everyone follows the rules. When that compact breaks down, justice becomes impossible. What Marcus Rennert and his team did wasn't zealous advocacy. It was an attempt to make the trial ungovernable, to create so much chaos that either the case collapsed or the conviction couldn't survive appeal. If that strategy works, if attorneys learn they can violate orders without consequence, every federal trial becomes vulnerable. Judge Caldwell understood the stakes. She knew ordering Marshals to remove and detain defense counsel would be controversial. She knew it would generate headlines. She knew she'd face criticism. She did it anyway, because the alternative was surrendering her courtroom to chaos. This affects every American who might one day depend on federal courts for justice. Plaintiffs, defendants, witnesses, victims. If courts can be sabotaged by attorneys willing to cross every line, the system fails. Judge Caldwell refused to let that happen. That's not tyranny. That's the rule of law, defended by someone willing to take the heat. If you want continued coverage of this story as it unfolds, hit that subscribe button right now. The appeals are coming, the bar proceedings are coming, the sentencing is coming, and I'll be breaking down every development. Subscribe so you don't miss it. Here's where things stand right now. All 3 defense attorneys have been released on bail pending their criminal contempt proceedings. Their hearing is scheduled for next month before a different federal judge, standard practice to avoid any appearance of bias. The defendant, Raymond Voss, has been assigned new counsel. His new attorneys filed an emergency motion yesterday seeking dismissal of all charges based on what they termed irremediable prejudice created by the courtroom spectacle. Prosecutors have opposed the motion, calling it an attempt to benefit from the misconduct of former counsel. Judge Caldwell has not ruled on the dismissal motion yet, but legal observers expect her to deny it. Her careful documentation in the contempt order appears designed specifically to preserve the prosecution's ability to retry. Meanwhile, the legal community is watching closely. The American Bar Association issued a statement calling the situation troubling, while notably not criticizing Judge Caldwell directly. Bar associations in multiple states have opened preliminary inquiries into the attorney's conduct. Conservative media has largely rallied behind Rennert, framing the removal as evidence of judicial bias. Liberal media has generally supported Judge Caldwell, emphasizing the documented violations. What to watch in the coming weeks: the contempt sentencing hearing, which could result in actual jail time, the bar disciplinary proceedings, which could end careers, and the dismissal motion ruling, which will determine whether Voss faces retrial. Perhaps most significantly, watch for the appellate filings. Rennert has indicated he will appeal everything: the contempt finding, the removal, and any sanctions. Those appeals will take months, possibly years. But the image of defense attorneys being handcuffed at their own table isn't going anywhere. That moment has already changed federal practice. The stakes have never been clearer. A federal judge drew a line. Defense attorneys crossed it. And now cell doors have closed, literally, on a legal strategy built on chaos. What happens next will determine whether federal courtrooms remain governable or become arenas for whoever is willing to push the furthest. Marcus Renner gambled that no judge would actually hold him accountable. He was wrong. And every attorney watching, every judge, every prosecutor, every defendant just learned where the line is. This isn't just another contempt case. This is a reckoning. Hit subscribe and the notification bell. The sentencing is coming. The appeals are coming. And I'll be here for every moment. I'll see you in the next one.